Are we live?
Yes.
Karen? We're live. Okay. All right. Let's do this. We're going to go on the record on this case. What is this? There we go. This is going to be on the cause number. Let me get to that. Okay, this is really long. Why don't we have Mr. Scott? Why don't you announce the cause number on this case?
Your Honor, it's DC 18-15106 for Cy Dallas Inc. against Jordan Zatoun and Aaron Zatoun. Your Honor, I'm one of the attorneys, the lead counsel for the defendants and third-party plaintiffs, Jordan Zatoun and Aaron Zatoun.
Okay. Opposing counsel?
Yes, Judge. Excuse me, Israel Suster and Tyler Smith on behalf of the plaintiff, as well as on behalf of the third parties, Dylan Elchami and Samuel Elchami.
All right, we have a number of hearings set for today, I know, so let's go ahead and get started.
Judge, the first item is on our motion to compel. There was a discovery served in a motion for protection filed by the defendants. So what I'd like to do is just kind of have a brief discussion of the case because it's all relevant, and I'll build up to the specific why these are all problems. I'd like to start out, Judge, as the court knows, we got into this case very recently, and apparently the last lawyer improperly bolted is what I will represent to the court. And so the client ended up scrambling and found us or asked us to come into the case, and we did. And so we've been cleaning up. I would also point out, until several weeks ago, there was a judgment in favor of our clients, the plaintiff, or at least there was a judgment on behalf of the plaintiff in this case, which, regardless of whether it was proper or not, had a significant legal effect on all of the issues. But let me start at the ground zero in this case for a moment, Judge, and that is that the plaintiff and at least the third party defendants or the people associated with the plaintiff and the defendants were friends. They knew they were good friends. They approached us to help them build a house. And in fact, at all times, Judge, it was a gratuitous deal. They were not doing it they were not charging for their time.
Your Honor, I'm sorry to interrupt, but I have to object. We've had 2 years of litigation that with pleadings and affidavits and statements by former counsel on the record at hearings that say what this case was. And this case is governed by a written construction agreement that the party signed. And now the 2 years after the fact, in response to a subpoena that we made to Prosperity Bank, we found that the builder signed a release of the claims that they're suing on. Now they have story number 3. But it's not part of these motions. What counsel's reciting is nowhere in their motion to compel. And it was not anything that was alleged. It wasn't part of the pleading. That was the live pleading at the time that they made these demands. So I'm sorry, Your Honor, I have to object to these statements by counsel trying to reframe this as some kind of a new case.
Judge, please give me leeway to set this up because the discovery has not been responded to, and it's important for the court to understand our position in this case.
Okay, go ahead.
Okay. So as I was saying, that these were friends and work was done and expended on behalf of these folks. And at the end of the day, our contention, as we've pled and everything, these people got together and settled the matter, and they agreed to pay us a sum certain. And the proof in the pudding is that they executed a promissory note in our favor, and they gave us a check. These are the defendants. The check bounced, or was NSF, and no payments were ever made on the promissory note. As a result, this is why Versailles is the plaintiff. We filed suit because of that particular breach. Now, just speaking in general, if I've built your house, Your Honor, and I've damaged your house in construction and I've done so many things wrong, why are you at the end of this deal agreeing to pay me monies? You would normally say, heck no, we're not going to do that, but you do, and you move forward and you sign a promissory note and you issue a check. Just hold that thought out for a moment in this case. So what happens is, at some point, the court enters a judgment in our favor until several weeks ago in this case. Now, they've amended to their fourth amended pleading recently, which added 2 additional causes of action for wire fraud or theft, and also they sued for RICO violations, which are generally federal racketeering, as I'm sure violations or claims, as the court notes. But I would point out that there are 7 causes of action against 3 parties. There are 25 affirmative defenses. If you look at their current pleading, and this is the same of their last pleading, it was about 23 pages long and consisting of 93 paragraphs, just talking numerically. Now, we started from where the other lawyers left off to the best that we could, and we served several sets of discovery on each of these parties. Now, I can prove to the courts, which is part of the record, that the discovery is customized and it is narrowly tailored as to each request. We went through the pleadings and asked questions based on the pleadings, and I can virtually defend every one of these things. And I would like to represent to the court, before I get into this, I cannot adequately represent and defend my client because they have given us 0 on everything with nothing but objections. And by the way, under Rule 193.2 E, if a party has numerous objections, unfounded objections, they are waived and should be waived by the court unless there's good cause otherwise to not waive them. And if we go by, Judge, if you go down to the discovery, I'm going to give an example. I think you're on their motion for protective order, I believe.
I'm just going through, I appreciate all this background, and it's always nice to hear from you guys, but we have a lot of motions set for today. So I'm just going to start going through each motion, and let's kind of look at it. Who sent out 1,896 discovery requests?
Well, that's what they're claiming we sent out. And what I'm saying is, you don't look at the numerics, you look at the actual request. If you look at, Judge, if you will find the discovery request, please, that they've attached, because our motion is based, we've incorporated by reference what they have attached, their objections to everything. And I'd like to start with that. And then we'll go over to our motion and the attachments so you can read through. Because I don't think you have, and I'm going to represent to the court that the majority of what we have filed are contention discovery requests. And we've cited a case, which is in Ray Sting, which has to do with contention discovery requests, which says that they're not privileged. There are virtually no objections to them, and they must be answered on that. And I'm very comfortable with that. But if you look at the first
So let me ask you this, 18, I don't know if this is true, but there is hundreds of them, I can tell. So I require that you confer on each and every one of these requests. And so I don't know if you want to do that now, or if you want me to put you into a breakout room and we can reconvene once you're finished, or how do you want to do this? But I can't imagine you've conferred on each and every one of these.
Well, but Judge, they filed a motion for protective order and they've objected to every single request. You are asking me to go through each and every one of them. Let me give the court an example, please. So they've attached this. This is the discovery request. For example, interrogatory number 11 to one of my sets. Identify all trial witnesses in accordance with Rule 192 3D of the Texas Rules of Civil Procedure. And the basic subject matter, such witnesses are anticipated to testify at trial. See objections above. Third party plaintiff is moving for a protective order and to quash. Let's do the next one. Please explain.
Judge, excuse me 1 second. They know for a fact that we've served a separate 192 disclosure. So this is 1,896 cumulative demands that include the request for expert disclosures. And when I met and conferred with Mr. Smith, you're right, Judge, we didn't have the time because it would take days to go through 1,896 demands. And I asked him to parse it back and he wouldn't do it. And I also pointed out to him that, in my opinion, they were acting as if there was no discovery in this case. And that's not true, because there was a first set of extensive demands that we've responded to with the former counsel. And Mr. Suster says he's going to represent that the other lawyers abandoned the client. That's not what they said when they moved to withdraw. They said the client didn't comply with the retainer agreement. But in any event, Judge, I want to just cut to the chase. My clients have produced everything that they have that would be responsive to these demands that's in their possession, custody, and control. And we have an affidavit, which we filed last week, that says exactly that. We produced 400 or 500 pages of documents, but we've gone a lot further, Your Honor, which is there's all these other custodians, the Prosperity Bank, the City Building Department, City Public Records. We did that work, Your Honor, and issued trial subpoenas. So since these 1,896 discovery demands were made, we've received those records and we've produced them to Mr. Suster and Mr. Smith.
So first of all, I think they filed an affidavit yesterday.
Let me just say this. I'm just kind of looking through this. This is how we're going to do this. You guys are going to confer on each and every one of these. And Mr. Suster, I'm going to give you one last option before we do that. If you don't reach an agreement on all of this, and I find that any of these, I mean, I've been doing this a long time. I don't think I've ever seen a case with 1,896 requests on them, even the cases far, far larger than this one. If I find that any of these are frivolous, I'm going to sanction you for the full amount of the time that's going to take you and Mr. Scott or whoever on his side is going to do this. And so I cannot imagine that all 1,896 of these are necessary and not duplicative, but it's possible. I haven't looked at all of them, but I'm going to give you the option to confer with Mr. Scott. You're right, this may take a few days, but Mr. Scott, if I determine that any of these are frivolous, then I will award sanctions against Mr. Suster for the full amount of your time.
Judge, how about the reverse of that? If you find that we have a basis and we've asked for this and they're proper, are you going to sanction them for all of our time?
If I find that all 1,896 of these are proper, then I will sanction Mr. Scott for the time.
Well,
if every single one of these requests, if there's not a single one that's duplicative or improper, I will sanction Mr. Scott. If there's even a single one that is improper or duplicative, then I'm going to sanction you for the time.
Thank you, Judge. We have another motion on as well, Your Honor.
No, I want to have you finish this one first.
Yes, Your
So I'm going to put you into a breakout room with Ms. Dondrazi, and I want you to start going over that. I don't know how long you have, Ms. Dondrazi. I'm going to put all the interns in there. You guys can sit in and you can start conferencing on this. And then once you're finished conferencing, and Ms. Dondrazi, if you need to leave at some point, obviously just text me and let me know. But if you need to leave, just text me. But you guys are going to need to be in the conference room. And then once you're finished, or in the breakout room, not the conference room, once you're finished, then just let me know.
Judge, look, I hear what the court's doing, but it's not going to be practical within a short period if you're going to require us to go through every one of the requests and what their objections are to remove it, because our position is they should not be objectioning. There's lots of them. They're all contention, most of them. They shouldn't have any objections. We can talk about that, but if what the court wants us to do is go one by one as to every request, we're not going to be able to do that in an hour. I think there have been discussions.
I'm going to leave this link open for you. Actually, you know what I should probably do? Because that would, well, I can keep this room open until Thursday. So I have another, actually, I can keep this open on Thursday even. So you guys will just be in this breakout room until you're finished. So, so you guys will be there. I'll have another hearing on Thursday, but I'll just keep this Zoom link open so you can stay in the breakout room. You guys will be allowed to take breaks for lunch at noon and then dinner at 6. But I do expect you to, and then you can break each night at 8 for this. So, and then you'll need to come back tomorrow if you haven't gone through each of these. I'd like a written report on this entire request on what you've agreed to and what you haven't agreed to. All right. Do you guys have any questions?
Your Honor, I just wanted to ask the court if we can, I understand what the court's ruling is. Can we address the other motion that's on at 10:45 today?
No, you need to finish this first.
Okay, Your Honor.
So, and once you finish that, that may be tomorrow, that may be on Thursday, that may be on Friday. I don't know how long it's going to take. I want you to talk about the substance of each and every one of these requests. And I expect a report on each and every one of these requests that may be, 10, 20, 30 page long. It may take you longer than Friday. I mean, because you're going to have to do a report on this, or Rule 11, I shouldn't say report, or Rule 11 on this, on what you've agreed to, what you haven't agreed to. The other option, Mr. Suster, is you can withdraw all of these requests and start over again.
Judge, as I'm sitting here before the court, if I can't say that every single request you might consider perfect, but I stand behind when we say we've narrowly tailored. So if we have to go through this, so be it. We'll do it to the best that we can, Judge.
Okay, we'll go ahead and put you guys in a breakout room. Just keep me updated. Intern stay as long as you can. Text me if you're going to be leaving the breakout room, and we'll keep this open. I can keep the Zoom link open until Thursday, or actually until Thursday night, and then we'll have to give you a new Zoom link.
Your Honor, I'm not going to be involved in that discussion. Is it all right if I do not stay in the Zoom room?
Who's that?
Joe Ackles.
Oh, if you're not conferencing, you don't need to stay.
Okay, thank you.
It's going to be one lawyer from each side. Just so that I understand, did you just say to text you, Your Honor?
I'm going to have the interns text me when they leave. You guys will just need to call my court coordinator to let her know kind of when you're leaving each day and then when you're coming back.
Okay.
I'll leave this breakout room, and if I have to take down the breakout room, I'll let you know. And if you finish somehow, say you finish at 3 o'clock tomorrow or whatever, 2 o'clock on Thursday, let her know, and then I'll try to get back on the Zoom call as soon as I can.
That's fine. And hopefully, I assume we can, once we're in the breakout room, I have an opportunity to talk to my co-counsel.
Sure, if you'd like.
No problem, Judge. Yeah, whenever
If
you're
you guys,
ready.
if you guys are able to work something out, you can. But I do want you, from Mr. Scott, if I do, or both sides, but Mr. Scott in particular, I want you to keep your time from the moment you enter the breakout room until this conference is over.
Thank you, Your Honor.
Same with you, Mr. Seuster.
Will do.
All right. Good luck, guys. I hope you can work out all 1,896 of these.
No problem.
Okay.
Thank you,
Bye-bye.
Judge.
Let's see if that works. Mr. Perez, what are you here for, sir?
Morning, Your Honor. I am here on Elizabeth Primentel v. Gasha Hamza. That's cause number DC-19-11455.
Was that on the trial docket?
Yes, Your Honor.
Okay. Let me look that up.
And I apologize for not being in proper court attire. This is last minute. I just realized that we had a hearing.
Let me see if I can find that. um, all right, let me pull this up. Give me 1 second. Or actually, give me the cause number again.
Yes, that's DC-19-11455.
Okay, yeah, I was going to DWAP that case, but you're here for that case?
Yes, Your Honor.
All right, so tell me what's going on in that case.
I believe that we're actually getting depositions rescheduled. We've had a little bit of turnover here in the firm. The previous attorney that was on this case has left the firm. We've just hired a new attorney that's going to be taking over the file, and we will be getting depositions scheduled here with that new attorney.
Okay. When do you want to reset this to?
If we could get, and I apologize for looking so far out, if we could get a summer of 2021 trial date, Your Honor, perhaps July or August.
Okay. How about July 13th?
That will work.
All right, great. We'll reset you to July 13th.
Thank you, Your Honor.
Did you get that, Rhonda? Okay, she got it. All right, you be safe.
All right. Am I excused?
You are excused.
Take care.
I think we still have an 11 o'clock.
You want to turn off your